4 fund managers including Newton Investment Management could have broken competition laws if they swapped information ahead of 2 stock market listings, the city watchdog has warned. The Financial Conduct Authority, FCA, has alleged that Newton, Artemis, Hargreave Hale and River and Mercantile told each other how much they were planning to pay for shares ahead of 2 floats in 2014 and 2015. London-based Newton, which is a subsidiary of banking giant BNY Mellon and was formerly run by Citi veteran Helena Morrissey, is the biggest of the 4 firms with £55 billion of assets under management. The 4 businesses, which together are managing more than £120 billion worth of assets, could be fined up to 10% of their annual turnover if they are later found to be breaking competition laws. If information was swapped before the share price was set, the investors would have had an advantage over others involved in the initial public offerings, IPO, and so may have broken competition law, the regulator said. Swapping trading intentions before a listing would mean the 4 could know the others' plans during the IPO or placing process when they should have been competing for shares, it added. The FCA alleged that Newton, Hargreave and River and Mercantile either gave or accepted pricing information ahead of an IPO and a share placing in 2015, a year after Newton and Artemis swapped information ahead of a listing. This is the first case the FCA has brought using the competition enforcement powers it took on in 2015, although it hasn't yet decided if the law has been broken. It would not name the IPOs involved. Spokespeople for the group said they would cooperate with the FCA as the investigation continues, with a spokesman for Newton saying there has not been and will not be any loss to clients or investors. A spokesperson for River and Mercantile added that no finding of wrongdoing had been concluded and the FCA's position is a provisional one only. Hargreave was acquired by Canadian financial services group Canaccord Genuity earlier this year, with a spokesperson for Canaccord saying this matter had been disclosed to the firm during the buying process.